Okay, hello, welcome to the final of the Speed Mooting Bail Application Competition 2023 in partnership with BPP. We've had performances throughout the day from our competitors, and we've gone from having 120 competitors in the morning down to a final. So they're now going to perform one by one for our panel of judges to compete to be the winner of our 2023 bail application competition.
Your Worships, today I appear on behalf of Mr. David Grant to make an application for bail. Mr. Grant faces a charge of assault occasioning actual bodily harm, contrary to Section 47 of the Offences Against the Person Act, 1861. Mr. Grant pleads not guilty to this offence and will argue that he acted in self-defence. The prosecution raises three grounds for objecting to Mr. Grant's bail, which I shall address in turn. Firstly, in respect of failing to surrender, Mr. Grant does contend that he did indeed fail to surrender in a recent unrelated drink driving offence. Mr. Grant has explained that his failure to attend court was an unfortunate administrative error, as he accidentally put the wrong date in his diary. Mr. Grant regrets this unfortunate oversight and acknowledges the cost of this to the courts, and now ensures that his diary is handled with more care. Nevertheless, if the court finds it necessary, a curfew would provide conclusive assurance on Mr. Grant's location. Secondly, I submit that there is no reason to suspect that Mr. Grant will commit further offences whilst on bail. Mr. Grant's previous domestic-related convictions cannot be ignored, of course, but Mr. Grant has since made positive changes in his life. I submit that these previous incidents are unrepresentative of his character today, and indeed the last of these convictions was some 8 years ago. Since then, Mr. Grant has obtained a professional qualification and employment in a well-respected managerial role, which he may very well lose if he is remanded into custody. Mr. Grant has not committed any criminal offences since gaining this qualification, and despite a challenging childhood, Mr. Grant now focuses solely on his work and caring for his 4-year-old child. Even so, conditions might be applied to Mr. Grant's bail to allay any fears that the court feels still persists. Indeed, many of Mr. Grant's previous convictions relate to offences committed whilst under the influence of alcohol. Therefore, I suggest that curfew as a condition of bail would prevent Mr. Grant from engaging in evening social drinking, which has preceded some offences in the past. Lastly, there are no substantial grounds to believe that Mr. Grant will interfere with the complainant. The relationship between my client and the complainant has now ended, and Mr. Grant has no reason to maintain any contact with her. He also intends to move in with his mother in Birkenhead, some 10 miles away from the complainant's home in Liverpool. Mr. Grant's family, friends, his job, and indeed his child are all based in Birkenhead, giving him little reason to leave the area. And his mother is in the court here today to provide assurance of her son's plans for accommodation with her. My client does not drive and so has little means of travelling outside of Birkenhead, and will willingly comply with a condition not to enter Liverpool at all if so ordered. Therefore, I submit that the court can rest assured that Mr. Grant will not interfere with the complainant, but any fears of such behaviour can be remedied with a condition not to enter Liverpool. I now turn to some additional factors for your consideration. The charge against Mr. Grant relies solely on the evidence of the complainant herself, who in fact initiated the dispute. Furthermore, when consulting the relevant sentencing guidelines, this offence undoubtedly falls in the lowest category of culpability, with the harm relatively low for an offence of this type. Therefore, contrary to the submission of my learned friend from the prosecution, I submit that there is no real certainty that if convicted, Mr. Grant would receive a custodial sentence. I also wish to note that prior to today, Mr. Grant has always pled guilty to the offences he has been charged with, as he has always acknowledged his guilt in those instances. But that is not the case here today. Mr. Grant has pled not guilty and intends to argue his case of self-defence fully at trial. On this basis, I invite you to conclude that Mr. Grant would have no reason not to attend court for fear of being convicted. He intends only to clear his name. However, I propose that the following conditions would address any risk that your worships may feel persists. Firstly, a condition not to contact the complainant. Secondly, not to venture into Liverpool, save for court appearances. And thirdly, to reside each night at his mother's address in Birkenhead. Mr. Grant will also abide by an electronically monitored curfew if the court deems it necessary. To conclude, My submission is that to deny Mr. Grant bail would be disproportionate, and that the imposition of the conditions I have proposed would address all of the concerns your worships or the prosecution may have. Unless I can assist you further, that concludes my submission.
Good afternoon, your worships. My name is Amelia Leventhorpe and I represent the defendant, David Grant. Mr. Grant has been charged with assault occasioning actual bodily harm. The prosecution objects to bail on the following grounds. Firstly, if the defendant is granted bail, he is unlikely to surrender. Secondly, the defendant will be likely to commit further offences on bail. Thirdly, the defendant would be likely to interfere with the complainant. And finally, this is a serious case that will likely result in a custodial sentence. In my submission, each of these concerns may be assuaged by conditional bail, with the conditions of residency at his mother's house, exclusion to not enter Liverpool except to attend court hearings, and to not contact directly or indirectly the complainant. My client is also happy to comply with any further conditions the court sees fit to impose, be that a curfew or an alcohol abstinence monitoring requirement. I will address you on each of these concerns in turn before addressing you on the defendant's personal circumstances. Firstly, regarding the concern that the defendant will fail to surrender, the prosecution is correct that Mr. Grant did not attend his first hearing for a recent drink driving offence. He informs me that he incorrectly noted the date and did not realise he was due in court. This was an unfortunate oversight and not at all intentional. It is a mistake and therefore it is unlikely to be repeated. Secondly, as to the prosecution's concerns that Mr. Grant will be likely to commit further offences whilst on bail, Mr. Grant does indeed have previous convictions for domestic-related assaults. However, he has not committed any offences since 2015, save for the drink driving offence, which he denies on the basis that he was misidentified as the driver. It is worth noting also that he has never breached bail conditions before. This directly correlates with the prosecution's concern that Mr. Grant may interfere with the complainant, as he has formed for previously doing so. In my submission, these concerns may easily be assuaged by imposing a condition of bail not to directly contact the complainant. Furthermore, a condition of residence at his mother's house in Birkenhead, some 10 miles away from Liverpool, would keep Mr. Grant even further away from the complainant. Mr. Grant has no ties to Liverpool and is also happy to be subject to exclusion from Liverpool, save for attending court. Finally, the prosecution objects to bail on the basis that Mr. Grant is likely to receive a custodial sentence. This is not relevant to the question of bail. Mr. Grant has a history of offending. However, since his last conviction in 2015, he has made vast changes to his life. In 2016, he obtained his forklift truck license, obtaining a job in a warehouse, and has worked his way up from the floor to a general manager. The job has been a hugely stabilizing feature in his life, and if he were to remain on remand, he would likely lose this job, for which he has worked so hard for so many years. It would be devastating for Mr. Grant to have his hard work undermined. Mr. Grant also has a 4-year-old daughter, custody of whom he shares with his ex-partner. He takes his daughter on the weekends that his ex works, and so if Mr. Grant were to remain in custody, both his ex and his daughter would be disproportionately affected due to the need to get childcare. There is a presumption in favour of bail, and to not grant it in this case would be disproportionate. Mr. Grant has always pleaded guilty to all prior convictions, and he is eager to return to court to prove his innocence. In my submission, Mr. Grant should be granted conditional bail with the following conditions. Condition of residency at his mother's house in Birkenhead. She has informed me that she is happy to provide this address. Condition to not contact directly or indirectly the complainant, and an exclusion from Liverpool City, save to attend court, and any other conditions that the court sees fit. Unless I may be of further assistance, these are my submissions.
If it may please the court, your worships, I am bringing a bail application today on behalf of Mr. David Grant. The main issue facing your worships today is whether Mr. Grant should be granted bail despite objections from the prosecution. These are that Mr. Grant is unlikely to surrender, is likely to commit further offences whilst on bail, and is likely to interfere with a witness. My submissions today are that despite these objections, there are no substantial grounds for bail to be withheld. Turning briefly, however, to the offence itself, last night, Mr. Grant was involved in a heated argument between him and the complainant at their home. I invite the court to take into account that Mr. Grant has been fully cooperative with the police, being compliant at arrest and giving a full and frank interview and answering questions when asked. He accepts there was some physical contact between him and the complainant, but he has pleaded not guilty to the offence, and this plea, your worships, lies in stark contrast to his previous record. Your worships may already be aware that Mr. Grant has a number of previous convictions, some of which are of a relevant nature to this charge. Mr. Grant concedes this also. However, I submit that Mr. Grant's record of entering guilty pleas every time at the earliest opportunity should be noted in contrast to the current charge, to which, as I have mentioned, Mr. Grant maintains his innocence. There has also been a significant lapse in time, your worships, since the defendant's last conviction, over 10 years, in fact. I will now address the prosecution's objections directly. Apart from one recent incident, the defendant has never failed to surrender to custody for any previous offences. The recent incident I refer to, your worships, was for a court hearing whereby the defendant had mistakenly put the wrong date in his diary. Despite this mistake, however, he has since appeared at court and been released on unconditional bail. Mr. Grant is aware of the seriousness of such a mistake, and I submit, therefore, there are no substantial grounds for the court to believe that this would happen again. Regrettably, Mr. Grant is facing another unrelated charge, which he's also contesting, and the offence being dealt with today, therefore, was committed whilst on bail. The defendant has, however, never previously committed any other offences whilst on bail and has always strictly adhered to any conditions placed upon him. I urge the court, therefore, to consider this incident in the context of Mr. Grant's previous record of compliance with bail and any conditions. He is aware he has a lot more to lose this time from further conduct such as this. Mr. Grant, as he stands before you today, your worships, actually paints a very different picture to the record of 10 years ago. Since 2016, he's been in a secure, stable job, trained as a forklift driver, and is also in a position of responsibility as a general manager, earning a stable income. Mr. Grant is also a father of a 4-year-old child, and importantly, your worships, he is a regular caregiver to that child at weekends, which allows the child's mother to go off to work. Understandably, perhaps, he is very worried about the prospects of 6 weeks in custody. He's worried about his job security in his local community and also even that of his ex-partner, as I understand there are no alternatives to childcare currently. Finally, the prosecution also object to bail on the grounds that Mr. Grant is likely to interfere with a witness. There is admittedly, your worships, a relevant conviction in Mr. Grant's past, but he has expressed particular regret and remorse to this charge, which he pleaded guilty to. Moving on to conditions, your worships, Mr. Grant has also expressed a willingness to comply with any bail conditions which may assist the court's decision. And indeed, one of those conditions may be to prohibit contact with the complainant with whom he's no longer in a relationship. Mr. Grant also tells me he intends to move out of Liverpool and back to his mother's house in Birkenhead, who incidentally supports him fully and this arrangement. Therefore, a residence requirement may be an option for the court to impose. With this change, Mr. Grant's life is centred on the Wirral, with everything he needs close by. Therefore, he would also be happy to comply with a condition not to enter Liverpool. And lastly, he would also be happy to be subject to a curfew, should the court wish, outside his working hours, for example, 7 p.m. till 7 a.m. Taken in some combination, I submit these conditions could fully meet any of the court's concerns regarding Mr. Grant. Unless I can be of any further assistance, your worships, that concludes my submission.
Your Worships, my learned friend has already outlined the facts of the case, as well as the grounds the prosecution is relying on to oppose bail. As you're aware, the burden is on the prosecution to show that these grounds are made out and that any risks cannot be mitigated by imposing bail conditions. I submit that the threshold for refusing bail has not been met and that Mr. Grant should be released on at least conditional bail instead. I will be addressing each of the prosecution's 3 reasons for objecting bail in turn. Let me start out with the prosecution's concern that he is unlikely to surrender, to which I have the following submissions to make. Regarding his previous failure to surrender, this incident has been acknowledged by Mr. Grant. However, he has explained that this was entirely accidental and he had no intention of not appearing to court for that hearing. He simply recorded the wrong date in his diary, and he fully regrets this mistake. Mr. Grant is committed to recording all court dates carefully moving forward, and therefore this isolated incident should not indicate any propensity to abscond again in the future. Secondly, it is not in Mr. Grant's interest to fail to surrender. He has pled not guilty and he wants his day in court to defend himself. As you can see from his antecedents, he has pled guilty to all previous charges in the first opportunity because he did commit those offenses and he owed up to them. The 2 offenses he was charged with this year are different. He vehemently denies committing them, and he wants the opportunity to defend himself at trial, so he will show up in court. Lastly, Mr. Grant has a stable address and he's moving into his mother's residence in Birkenhead. I've spoken to his mother and she's committed to ensuring that Mr. Grant does not get himself into trouble again and that he makes all future court hearings. However, if your worships are still concerned, then it might be appropriate to impose a bail condition requiring his residence at his mother's address. I will now turn to the second concern raised by the prosecution, that he is likely to commit further offenses on bail. To address that concern, I submit the following. The 2 previous domestic-related assault convictions occurred in 2010 and 2015, over 8 years ago. Mr. Grant admits that he has committed these offenses. He has shown deep remorse for his past actions. However, these offenses occurred a long time ago, and Mr. Grant has since then become a changed man. Your Worships, Mr. Grant has worked hard to rehabilitate himself and to turn his life around over the past 8 years. In 2016, he has obtained a professional qualification as a forklift driver, and he now holds a respectable job with a very decent income. He also has a 4-year-old child he cares for on the weekends. He has not committed any other offenses since obtaining his qualification, and he does not want to risk his relationship with his child and the stable life he has worked so hard for by committing any further offenses. However, should you still continue to be concerned about this risk, then I would recommend imposing a curfew condition on Mr. Grant's bail, which would require him to stay at home with his mother during the hours of 7 p.m. and 7 a.m. whilst he is not at work. Lastly, regarding the prosecution's concern that he is likely to interfere with the witness, Stephanie, Mr. Grant admits that his previous convictions for harassment and witness intimidation took place. However, those date back to 2013 and 2010, over 10 years ago. Mr. Grant has learned from those cases and he deeply regrets his past behavior. Over 10 years have passed, and as I've already submitted, he has made significant changes to his life since then. Regarding Mr. Grant's relationship with the complainant, this relationship has now ended. And as I mentioned, Mr. Grant has moved out of the joint home and is now moving into his mother's residence in Birkenhead. His mother's house is located over 10 miles away from the complainant's home, and Mr. Grant has no other ties in Liverpool or any other reasons to visit that area. He is therefore not likely to interfere with Stephanie or any other potential witness. Having said that, should you have any lingering concerns regarding witness intimidation, it may be appropriate to impose an exclusion condition on Mr. Grant's bail, whereby he will be prohibited from entering the Liverpool area. He is happy to comply with this. To conclude, the ramifications for this young man, if he is not allowed to go home today, will be severe. He will likely lose his job if he is remanded in custody for 6 weeks. He will not be able to take care of his 4-year-old child on the weekends, and there's a real risk of him losing all of the progress he has made over the past 8 years. At the same time, any residual risk in allowing Mr. Grant bail can be mitigated by the robust bail package I've presented today. Mr. Grant has never breached a bail condition in the past, and he's also willing to comply with any other conditions that the court sees fit. Unless I can assist the court any further, that concludes my submissions.
Good afternoon, Your Worships. Your Worships, the prosecution has raised and are seeking to rely on all three of the exceptions listed in Schedule 1, Part 1, Section 2, Subsection 1, to rebut the general right to bail under Section 4 of the Bail Act 1976. I will address each in turn. On the likelihood of failing to surrender, the prosecution are noting the defendant's failure to surrender on the 17th of November as evidence that he will fail to do so once more. It was an honest mistake. He accidentally put the wrong date in the diary. It's hugely regrettable, but human errors like these do happen. Ultimately, as per the wording of Section 2, the court needs to be convinced not that he has failed to surrender in the past, but that there is substantial grounds to believe that he will fail to do so this time. A diary error is easily resolvable and unlikely to reoccur. In terms of the likelihood to commit further offences whilst on bail, if we dig a little deeper, we can see that this is an oversimplification on the part of the prosecution. Prior to the offence committed in November, he had not been charged with a single offence in almost 7 years. He was a reformed man. In any case, the circumstances are not the same as before. The defendant and the complainant no longer live together, so there is a low likelihood of any further domestic altercations. Further, he doesn't have a car, so there's no real risk of drink driving again within the next 6 weeks. In terms of the likelihood of witness interference, as mentioned, he and the complainant are no longer living together. They're no longer together, full stop. They're not in contact. He doesn't have a car. He won't be living in the same city. So the likelihood for interference is vanishingly low. In terms of his former conviction for witness intimidation, it was a spur-of-the-moment reaction to bumping into his ex on the street. The chances were low, and they would be much less likely to happen this time, as he'll no longer be in Liverpool. He'll be 10 miles away in Birkenhead. And I should point out that the defendant is also very happy to accept bail conditions should the court deem it necessary to do so, to further ensure that no interference takes place. He's indicated a willingness to stay away from Liverpool. He has no reason to go there. His friends and family and his work are all in Birkenhead. And another bail condition that might be effective would be to impose a curfew tailored around his work shifts. And that would further allay any concerns on interference and reoffending during the bail period. Finally, the prosecution have also looked to Section 9A of Schedule 1 as a consideration to take into account in terms of the seriousness of the case. In reality, the culpability and harm are of a relatively low level, likely C2 in the sentencing guidelines. It's clearly of lesser culpability, and the physical injury is not overly serious. It'd be more suited to a high-level community order. In terms of other considerations, there's just two else that I would like to raise. Firstly, the strong likelihood that he will lose his job. This would be devastating for multiple reasons. Firstly, it would endanger his livelihood. This is all he's qualified in. And I think there's a worry that if he were to lose it, then there might not be an equivalent role out there for him to be able to take. But perhaps more importantly, the job was crucial to him mending his ways and putting him on the straight and narrow. And I think there's a very real worry that if he were to lose it, he would be directionless again, and he might fall back into old habits. Then there's the effect it would have on others. He has a 4-year-old child from a previous relationship with whom he has commitments to fulfill. It looks after him on the weekends. That's when the ex-partner works. So it would be difficult on the ex-partner, the child, and the defendant to make alternate arrangements. So in short, what we're dealing with here is a reformed man and father who has an awful lot to lose by being remanded. His career would be jeopardized, his family would suffer, and it isn't necessary. He is likely to surrender to custody for trial with the right date in his diary. He is unlikely to interfere with the witness given their breakup and his living in Birkenhead and with a curfew. And for the same reasons, he's unlikely to commit another offence during bail. So it makes sense for him to be allowed to continue his bail, not lose his job, and prevent family disruption. Unless I can be of any further assistance, those are my submissions.